Next, we will move on to Proposition 122, access to natural psychedelic substances. Will Aaron Carpenter, who I see has already joined us, please proceed with your presentation.
Thank you, Mr. President, and good morning, members of the committee. My name is Aaron Carpenter from Legislative Council staff, and I'm here today to present to you our analysis for Proposition 122, or access to natural psychedelic substances. Before I begin, I just want to thank my writing team of Amanda King, Jeanette Chapman, and Colin Schroeder, as well as my review team, Natalie Molis, Kathy Esslinger, Bill Zepernick, and Greg Sebeski, as well as our wonderful staff assistant, Marie Garcia. So to kick off our analysis of Proposition 122, Proposition 122 proposes amending Colorado statutes to do two things. The first, to decriminalize the personal possession, growing, sharing, and use, but not sale, of 5 natural psychedelic substances by individuals over the age of 21, including 2 substances found in psychedelic mushrooms, including psilocybin and psilocin, and 3 other plant-based psychedelic substances, dimethyltryptamine, or DMT, ibogaine, I think, and mescaline. The second things it does is, by late 2024, allow for the supervised use of psychedelic mushrooms by individuals aged 21 and over at licensed facilities, and requires the state to create a regulatory program to regulate the facilities as well as facilitators. The substances offered in these facilities may be expanded to the 3 other plant-based psychedelic substances I had mentioned before, in 2026. So that's what the proposition is doing. In our summary and analysis section, we discuss how the measure allows individuals over the age of 21 to use natural psychedelic substances in 2 ways, through personal use and through licensed facilities. We then go into how these substances are treated under state law and federal law currently, and how the measure will change how these substances are treated if the measure were to pass. We then talk about if these substances have any medical uses, how the proposition requires the state to regulate these substances, what restrictions the measure places on the use of these substances, and the criminal penalties and legal protections that are outlined in the measure. In our arguments and arguments against section, we have 2 arguments for each. For the arguments for, we discuss how the substances may help Coloradoans who are struggling with mental health to find effective mental health treatment, and how placing people in jail or prison for using naturally occurring substances with potential mental health benefits does not benefit society and cost taxpayers money. In our arguments against section, we focus on how these substances may still be dangerous and are not an approved treatment by the FDA, and that the measure allows a Schedule I drug for personal use that may be used to expand a black market, putting people's safety at risk and creating additional burdens on local governments. Finally, the fiscal impact statement discusses how the measure will increase state revenue and spending, as well as impact local governments, and that's it. I'm happy to take any questions.
Thank you, Mr. Carpenter. Are there any questions from the committee? Seeing none, we will proceed to the public testimony phase. And it looks like we do have 3 people signed up to testify. We will just bring all 3 of you up at once, if that's okay, for efficiency purposes. Will Melanie Rogers, Renee Millard-Chacon, and Nicole Forrester please come to the table? And it looks like Renee is remote, so we will look for you on the Zoom and get to you after the first 2 in-person witnesses.
I'm not on the list.
Okay, we will get to you, and we'll just have you sign up afterwards. Are you Ms. Rogers?
I'm Nicole Forrester. Melanie's on her way, to my knowledge.
Got it. We will start. We will start with Ms. Forrester and proceed from there. Please begin with your testimony, identifying yourself, who you represent, and you have 2 minutes to testify.
Thank you. My name is Nicole Forrester, and I'm here today representing myself, but I'd also like to note that I am the director of a nonprofit titled Decriminalize Nature Boulder County that is leading decriminalization efforts in Boulder County, Colorado. And I was also co-proponent of Initiative 61, which did not get enough signatures to be on the ballot, but it intended to decriminalize the same substances mentioned in Proposition 122, and it was drafted by community in response to the Natural Medicine Health Act under concern that not enough diligence had been done by proponents of the Natural Medicine Health Act to include communities that will be affected by the act if it passes. So I just want to give that background. Specifically today, I would like to comment on an amendment to that you guys will be discussing, that it intends to replace the term substances with medicines. And I also want to mention that I do work in healthcare and have worked in the healthcare field for the last 10 years. I have some hesitancy seeing that you all are trying to change this term to medicines, because I could see how that might be potentially misleading to voters who are not aware of these medicines. Under the decriminalization side of things, we may have people who are using these substances for medicinal purposes, but as the campaign strives to legalize and regulate these substances, they are doing so promising safety. And I can see how the term medicine might mislead the naive general public into thinking that these are medicines that have been, approved by the FDA, rather than what is actually happening in this act is that we're changing the way laws around controlled substances are handled. So I would support keeping it substances so that it's more clear that we're talking specifically about the substances within the natural occurring plants rather than things that are medicines, even though they may be used medicinally by people. I want to hit on the distinction between somebody making their own choice to use a medicine, to use a plant that they have a relationship with as a medicine, and that they should be protected by the law, versus the accountability process that needs to take place from somebody who is profiting off of the guise of healing somebody and calling that a medicine, whereas it hasn't gone through the same process of being proven to be safe like the FDA would allow, if that makes sense.
Thank you, Ms. Forster. And sir, we'll move on to you. Could you state your name, who you represent, and proceed with your 2 minutes, and we will have you sign up afterwards.
My name is Travis Tyler Fluck, and just to give you some context, I was leadership on the decriminalization effort for psilocybin in Denver. And the last 3 years, most of the scope of my work has been in educating the public about these substances. And I want to just echo a lot of what Nicole had mentioned about kind of like meeting people where they're at with their perception of these substances. And I, for one, see this as a medicine, but in talking to the naive public and meeting them where they're at, they're still stuck with the general information that the Controlled Substances Act has provided, that this is highly addictive and not a medicine. And the Controlled Substances Act uses the word hallucinogenic, and in nowhere does it mention anything about psychedelic or natural medicine. So I would say that the first draft was a little bit more true to meeting the voter where they're at and creating as little confusion as possible. So really that's my comment, is about the interchangeability of these words is only seen through evolved awareness and education around these substances. Thank you.
Thank you for your testimony. We will now move on to Ms. Renee Millard-Chacon, who I believe is joining us remotely.
And all the ones that came before, and all the little ones to come. We live on the land of the Ute, the Cheyenne, the Arapaho, the Lakota, the Shoshone, and 48 tribes that still live and travel to the space we call Colorado. I'm Renee M. Chacon. I work on the Environmental Justice Action Task Force for CDPHE, co-chair of Equity Analysis with Beatriz Soto. I am also a co-founder of Women from the Mountain, indigenous nonprofit specifically working in cultural education, equity, and transformative art. I've worked with several indigenous communities from around the state. I've grown up in those spaces, and we are highly against this space because it includes specifically mescaline, and it has absolutely no equity analysis with cultural trauma sensitivity of the actual endangered species, specifically peyote and other medicines that they claim to represent. This actually creates a predatory pattern of exclusion, ignorance, and narrow-minded profit-driven agenda rulemaking policy with no equity, proving that they can be the same colonizers to indigenous communities. This can be harmful in behavior, including exacerbating the issue of missing and murdered indigenous relatives and sex trafficking and many other forms of trafficking without this awareness when there's no cultural trauma sensitivity increasingly on our overburdened and fragile communities. We have already faced this issue before several times and over the generations and have asked for forms of equity analysis to be involved with cultural education responsiveness of the indigenous and disproportionately impacted communities, historically known for protecting and transformatively using our medicines with respect to our communities, the medicine, and the biosphere. I work in state and federal agencies to represent and protect these forms of equity, education, and medicine for our community and biosphere. And we've spoken up against this specifically because it's a harmful predatory industry that does not actually hold itself accountable to every community, that including the biosphere, that can potentially be harmed. And they need to first earn that trust with respect and humility for those communities, behaviors that this industry can also be predatory before they start instilling a whole entire agenda and rulemaking in this space, and also be aware of past generations, current generations, and future generations' sources of life, including those medicines being and any type of cumulative impacts to the biosphere being responsibly held with cultural responsiveness and education first, and equity analysis so that this does not completely become another climate and environmental injustice without any cultural and trauma sensitivity. I ask this that before these types of legislation and rulemaking come forward, that they actually work with the local tribally affiliated people of our state first before they start introducing medicines that can potentially harm communities without cultural education and these forms of trauma sensitivity. I thank you, and if you'd like to ask any questions or reach out for anything, please do.
Great, thank you. We appear to have Melanie Rogers, I think, with us now. So we will proceed with your testimony, and then we'll open it up for questions from the committee for all of you.
Is this on? Yes. Hi, everybody. Hi, Legislative Council. Thank you so much for having us and to provide this public testimony today. Melanie Rose Rogers, you might have seen me here in 2019, founder of Safe Access Colorado. And also, I'm the co-founder of Expunge Colorado. We do record sealing work throughout the state. But I'm here to represent myself today. I, along with Nicole Forrester, were co-proponents behind Initiative 61, which was a decriminalization-only initiative. So I'd like to just provide some concerns I have about the Blue Book. I also, in 2019, was a co-petitioner behind Denver's Initiative 301 that decriminalized psilocybin mushrooms in Denver. And I will say for the record, I have grave concerns about the Natural Medicine Health Act and how it's worded in the Blue Book right now. And I believe it is misleading voters. And then I have 8 points for you today. And the text of Proposition 122 states that licensed facilities will administer psilocybin and psilocin. It does not state that they will administer psychedelic mushrooms. The voter package should accurately reflect the language of that proposition. So on page 1, line 7, the Legislative Council states, by late 2024, allow the supervised use of psychedelic mushrooms by individuals aged 21 and over at licensed facilities. However, the Proposition 122 states that the facilities will administer psilocybin and psilocin, not psychedelic mushrooms. It is possible that the governing agency, DORA, may decide not to allow the administration of psychedelic mushrooms because the proposition does not specify the source of psilocybin and psilocin and gives the agency discretion to determine the source of psilocybin and psilocin. To be accurate, this paragraph should state, by late 2024, allow the supervised use of psilocybin and psilocin, 2 substances found in psychedelic mushrooms, by individuals aged 21 or over at licensed facilities. This error is repeated on page 1, line 29, which states and requires the state to establish a regulated system for accessing psychedelic mushrooms. It is repeated again on line 2, page 2, line 14, under the heading licensed facilities. So that's Point one. Point two, the FDA has not designated psychedelic mushrooms as a breakthrough therapy. It has only designated 2 specific formulations of synthetic psilocybin accompanied by proprietary treatment protocols breakthrough therapies. So on page 2, line 33, the legislative draft states, the U.S. Food and Drug Administration has designated psychedelic mushrooms as a breakthrough therapy for treating depression. That is incorrect. The FDA has only given this designation to 2 proprietary synthetic forms of psilocybin produced by Compass Pathways Limited and Usona Institute. Consequently, the term psychedelic mushrooms on page 2, line 33, should be replaced with synthetic psilocybin.
Ms. Rogers, I appreciate that you are only on point 2.
I know.
However, we are giving everyone just 2 minutes, and your time expired about a minute ago.
Oh, it did?
I will ask you to conclude in the next couple of seconds, and then we'll open up to questions, and there may be questions that you can add some context to.
Okay. My last thing is that to clarify that if the proposition passes, the psychedelics listed will be partially decriminalized because personal possession above limits determined by DORA may result in arrest and prostitution. So that's it. Partially discriminalization. Thank you.
Thank you. Questions from the committee for any of the 4 witnesses? Seeing none, thank you to all 4 of you for being here today. And sir, I'm not sure if we got your information, but we will get you a sign-up sheet.
Do I sign up over there?
We'll provide it right now.
Thank you.
Is there anyone else in the audience who wishes to testify who did not sign up? Please come forward. And we will ask you also to sign up afterwards so we have your information for the record. Please state your name, who you are representing, and you have 2 minutes for your testimony.
Okay. Thank you so much, and I welcome the opportunity to speak with you. Thank you so much. My name is Peter Grishoni. I was the field coordinator in the 2019 Denver DCRIM. I just have a couple of comments about this initiative here. First, I've seen the amendment 2 that they proposed here, and this was also came up in previous drafts of how they would want to use this term natural medicine. And sort of echoing what the other folks have said, but also adding on, natural medicine implies things like echinacea and ginkgo, things that the public typically see as supplements that are widely available over the counter. These are very different substances than were actually being proposed in this initiative. These are psychedelic substances. They have different mind-altering effects than echinacea does. And so using the term natural medicine, I think, is very misleading for the public. A second comment is around, it's a combination of a question and a comment. So this initiative proposes to prohibit local governments from banning these healing centers. And I have a question as to the constitutional viability of that. In comparison, Amendment 64, which was the legalization of cannabis in Colorado, it specifically allowed for localities to opt out, so it preserved home rule. And it was structured in almost the same way in the sense that it had a regulated component, a regulated access component, as well as a personal use component. And it was dealing with substances that were controlled by that were outlawed by the Controlled Substances Act and that were being made more available to the public. So in a similar way, this one is doing the same thing. And given that Amendment 64 preserved home rule, I'm not sure where the viability, whether this is even going to be allowed to happen to prohibit prohibit local governments from banning these. So on top of that, if this group decides that that's not within your purview to decide, then at the very least that should retain a prominent place in here so that the public knows that there is an attempt to subvert home rule. Thank you.
Thank you. Any questions from the committee? Seeing none.
Thank you.
Thank you for being here. Is there anybody else in the audience who wishes to testify who did not sign up? Thank you for being here. Please state your name, who you represent, and you will have 2 minutes for your testimony.
Thank you. My name is Taylor West. I am here on behalf of the Natural Medicine Colorado campaign, which is the sponsor of the Natural Medicine Health Act. I just wanted to address the idea that natural medicines is a term that should be maintained in the Blue Book primarily because it is consistent and aligned with the title that was approved by the Colorado Title Board. This is important because there are a couple of things that natural medicines outlines. One is that these are, in fact, substances that are all naturally occurring. They either occur in plants or in fungi. The other is that these are all substances that are intended to be used in a therapeutic setting. We are creating a regulated access program that is not intended for recreational use. This is intended for people to seek healing, and that is, in fact, what medicines are intended to do. So the term natural medicines is, in fact, the most accurate way to explain to a voter what it is that we are talking about changing policies on. It's important, too, because, frankly, some other psychedelics and other hallucinogenic substances are either synthetic, meaning not naturally based, or fall far outside the subclass that is included in this bill or in this initiative. But most importantly, we know the point of the Blue Book is to make it very easy to understand the somewhat complicated ballot title language and explain what you're looking at when you're looking at each of those documents. And so consistency with the language that was approved by the Title Board through a deliberative process is important to maintain. And I'm happy to answer any questions if people have specific questions around that point.
Great, thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Okay, one last time. Anybody else in the audience who would like to testify who did not sign up? Seeing none, the testimony phase is now closed. And moving on to the amendment phase. Are there amendments from the committee? Senator Smallwood.
Thank you, Mr. President. I move Amendment 1.
To Amendment 1.
Colleagues, Amendment 1 is really easy. We're adding one word, potentially, and this is on page 4, line 6. So when we're looking for arguments for, you'll see all over on page 2, when we're talking about the substances having medical uses, you'll see the word potential on line 30. May offer substantial improvements on lines 36, 37. On page 4, line 8, may provide effective treatment. Line 10, mushrooms may offer substantial improvements. Line 13, substances may help people. So what I would propose that we consider would be putting potential when we're talking about this being a valuable tool that's being provided, and I would ask for your aye vote.
Senator Donovan.
Thank you, Mr. President. In terms of just consistency and clarity throughout, I'm supportive of this. I think it's a great amendment.
Thanks, Senator Donovan.
Any other discussion on Amendment 1?
I mean, I'm going to vote against it, but I think it's a great amendment.
None. Ms. Wallace, please take the vote on Amendment 1.
Senators and Representatives, Benavides.
Yes.
Coleman.
No.
Cook.
Aye.
Donovan.
Aye.
Escar.
Yes.
Gardner.
Aye.
Geithner. Representative Geithner.
Yes.
Hansen.
Aye.
Kennedy.
Yes. Yes.
Malika.
Yes.
Pelton. Smallwood. Valdez.
Yes.
Van Winkle.
Aye.
Moreno.
Aye.
Mr. President.
Aye.
Passes 17-1.
That amendment passes 17-1. Further amendments on Proposition 122. Senator Donovan.
Thank you, Mr. President. I'd like to talk about Amendment 2 to Proposition 122, which I tried to get to many of you at the start of the meeting and is released as well. Proposition Amendment 2 looks extensive, but let me walk you through what it does, because it's one of those that takes a lot more writing than maybe what it was trying to accomplish. It might be helpful to pull out the page 1 of the green and then have alongside of it the first one of the blue. Because what all of the striking and then inserting does is just reorders existing language. So if you look at the ballot title on our green page, it very roughly, I'm going to say, talks about regulation, local control, and then possession. The proposed blue page language talks about possession, regulation, and local control. So we just want to reorder the explaining language on the blue page 1 to match the orders, so that folks who are like my mother that like have them side by side and read through them, the arguments are just naturally more paired, so people can understand the proposed title. That's one part of Amendment 2. The other piece is you will see on line 2 on the green page where we see line 2 and 3, legally regulated access to natural medicine. The Blue Book introduces a new term as proposed of psychedelic mushrooms. We don't see that language used in any of the proposed ballot title language. And so we would like to mirror, I would like to mirror that natural medicine, same terminology instead of introducing psychedelic mushrooms. I would say I mean, I'll be forthright with you guys as I always am. You can look at this politically. I hope you wouldn't. It's not the intent of this amendment to try to create a new pro or con approach to it. It's just purely trying to be more consistent with the ballot title language and not have new words or verbiage and create more clarity for voters to then decide if they want to approve this or not. Another comment that I've heard is, well, are we trying to hide the ball a little bit? Like, are we playing a shell game? I'm certainly not. I'm not approaching this in a pro-con position, just trying to be consistent. And I would say of any ballot measure that's going to be run, this is going to be one that gets more attention in press, I would say, because just talking about this is going to be a topic that likes to be covered. So I don't think there's going to be any confusion about if we keep about what Proposition 122 a vote is on. But I do appreciate, as was our very introductory statement from our staff, the intent of the Blue Book is clarity and providing information. And as it is now, I don't think it's the most clear as it could be for people making an important vote. I'm happy to answer questions because I know Amendment 2 does look extensive, but it's a lot of reordering of the language to, again, get that same parallel structure between the two documents and then making sure that we're using the same language across the thing that we're asking people to vote on and the thing that provides the information to help them make that vote.
Senator Donovan, I may have just not heard it, but could you move the amendment?
Oh, I didn't move it. Yeah, I move Amendment 2. Thank you, Mr. President.
Thank you. Representative Benavides.
Thank you, and thank you for the amendment. I have two questions, and one is, I don't really have a problem with the natural medicine term because that is used and defined in the referred measure as to what it is. I'm just wondering, is it also somewhere defined in the Blue Book information that will be going out?
Senator Donovan.
I don't believe so, but that's probably actually a question better suited for the drafter.
Mr. Carpenter, you provided some information to that question.
So now, all right. Thank you, Mr. President. Senator Donovan, Representative Benavides, you had the question. Sorry. So we do list right now in the analysis, for example, on page 1, it says 5 natural psychedelic substances, and then we go into what those substances are. I don't have the amendment right in front of me, but I believe that's an example of that might get struck to say, 5 natural medicines. I can't remember exactly what the amendment says, but then the substances would be listed, I believe, after that change, if that makes sense.
Representative Benavides.
You had me going for a while till you said that. Where would they be listed? Because I see they're listed on lines 2 to 6 if we adopt this amendment, which will be struck. And they're not listed the same way they're listed on page 3 of the referred measure, lines 27 through 30, because mescaline exempts peyote. So they're not exactly the same as the referred measure. But if that goes away, then you were saying, but they will be listed or explained somewhere else. Where would that be?
Mr. Carpenter.
Thank you, Mr. President. Representative, I was just trying to say that I believe those substances will still all be listed. What was being changed was what those were being called, whether it was psychedelic substances, natural medicines. So the amendment, I believe, should just be deleting those like natural psychedelic substances and changing that to natural medicines, and then still having those substances listed. To your peyote question, I don't believe it is mentioned on page 1. We do mention it under the how are these substances currently treated under state and federal law section, I believe, on line 26 on page 2. So that's where you could find that peyote question that you were asking.
And just thank you. And just to clarify, I was asking because of that language on page 2, where it says that it doesn't decriminalize peyote, a type of mescaline, whereas it does decriminalize other types of mescaline, just not peyote. And that's what's not at all clear. But I see what your point is on the amendment. It would add the second paragraph and at least list the 5, but not clarify mescaline. So thank you for that. And that brings up my second question, which you might want to stick around for, which is, and I know this is already in, it's in the referred measure and it's in the other draft. It's decriminalizing the possession, growing, and sharing. Sharing, and I don't know, Senator, if you know, but sharing under possession, and Senator Gardner may know better, that is possession, because we had a lot of discussion over bills this year as to if people shared a drug, and is that considered more than just personal use? So it's not part of possession. It would go beyond that. So I'm just wondering, is sharing that term confusing for possession?
Mr. Carpenter.
Thank you, Mr. President. Great question, Representative. The term sharing, I believe we were trying to encapsulate this, that the measure allows individuals to possess and give out without selling these substances. So we were trying to encapsulate that in the word sharing. So that's why we use the word share.
Representative Benavides.
I guess I was just wondering, and it's the fine line between what's possession and what's distribution. And would we be treating this drug differently than other drugs? Because I think on distribution, sharing could be considered distribution. So this would make this treated very differently than other drugs. And I was still hoping Senator Gardner would weigh in.
Mr. Carpenter? And if you have nothing else to add, that's fine.
Thank you, Mr. President. I guess I just want to say I'm not an attorney or anything, so I don't want to go too far down that road. So,
Can I?
Senator Donovan.
Thank you. And Representative, thank you for the question. I would just point, again, I think this tension that we feel a lot of times, that sharing is in the ballot title language. So again, we see a lot of that language pulled in. I think it's a great question. but a lot of our stuff, it sounds like maybe we should have gotten to the title board, and now as a body we're reacting to what the title board approved with that word sharing in there and with the words natural medicine as well. But really important question.
Majority Leader Moreno.
Thank you, Mr. President. And Mr. Carpenter, I'm sure you've seen this amendment since I suspect you drafted it. This amendment proposes to conform the Blue Book language with the initiative, which in one sense makes sense because that's the terminology that's used in the Blue Book. But I'm curious if staff can opine a bit on what the purpose of the initiative is versus the Blue Book. Because in my understanding, it's that a ballot initiative is a legal proposition, and so there has to be certain terminology used there, versus the Blue Book, which is designed to help voters understand. So if you could kind of give us some thoughts there, and in conjunction with that, why did staff land on the term psychedelic mushrooms as opposed to natural medicines?
Mr. Carpenter.
Thank you, Mr. President and Mr. Majority Leader. I guess I'm going to start with why we chose to use the term psychedelic substances and psychedelic mushrooms. There's kind of like a couple different ones in here, but I guess as a writing team, the term medicine, because this doesn't have FDA approval, because we're still doing studies around it, we didn't feel comfortable using the term medicine since it felt argumentative. Some people might say this is a medicine, others say that this is not a medicine. So we didn't want to put the word in to say to the voters, this is a medicine or isn't a medicine, because of that argumentative, how we felt it was argumentative. So we decided to try to find it more neutral. I know you guys also heard of like hallucinogenic for psychedelic as well. There was a lot of discussion in our writing team about those two terms. Ultimately, we ended up on psychedelic in that it seems that a hallucinogen is a broader term that composes a lot more drugs that aren't included in this measure, and psychedelic is a little more specific in that. And then also a lot of the studies, when we were doing our research, a lot of the university offices, that sort of thing that study these things, pretty much all use psychedelic. So we landed on the term psychedelic substances to try and create that neutral and not use what we felt was kind of an argumentative word of medicine. Another thing about aligning with the question presented by the title board was the order of which we put the what the measure does. Since we flipped it with decriminalization first and then the regulatory, we just did that for chronological sakes, because when the measure passes, our reading is that the measure will decriminalize as soon as this passes. And then in 2024, we will now have a regulatory system for these things. And so we wanted to communicate that what would happen first is the decriminalization. We didn't want to put the 2024 number first to the voter, so then they thought decriminalization would be happening in 2024, or all these things would be happening in 2024. So that's why we did the flip. We wanted to, show it chronologically to the voter that first they will decriminalize, allow personal use, then the 2024 system, then the 2026 expansion, which is our third point. Does that answer all your questions? Did you have another part, or?
Majority Leader Moreno.
Thank you, Mr. President. Thank you, Mr. Carpenter. Yeah, that mostly answered my questions. The last piece was just about the difference between an initiative and the Blue Book. And, it's my understanding, right, that in the initiative process, it's a legal question. It's a legal proposition. So very specific terms, legal terms, are important to maintain. With the Blue Book, it is more acceptable to use colloquially known terms because you're trying to help the voter understand what's happening. So I just wanted to see if that played a role in how you landed on the terms that you put forward.
Mr. Carpenter.
Thank you, Mr. President. Mr. Majority Leader, that is my understanding, and also reminds me, like, this is why we use terms like psychedelic mushrooms instead of psilocybin, psilocin. We felt that a voter would understand that more than repeating psilocybin, psilocin.
Director Mullis.
Thank you, Mr. Chair and Majority Leader Moreno. I just wanted to comment a little bit on the broader question of whether or not the Blue Book ballot analysis needs to mirror the question or the title that is written by the title board. And that is, I mean, I think usually it does, but it's not because we do it that way on purpose. I think it's just because maybe great minds think alike. We don't look at the title and mirror our, write our analysis to mirror the title. The two things have two entirely different purposes. Our entire goal is to communicate the information in the most clear and understandable way to the reader, and frankly, we don't even look at the title at all, other than reading it to know what the voter is going to see when they vote on their ballot.
Just so folks know, to the committee, I know Representative Geithner and I believe Minority Leader McKean have comments and discussion as well. I'm inclined to lay this one over a couple of measures to see if there is sort of a path forward. Happy to take the comments that are in the queue, but if that impacts your comments, just wanted to let you know that my inclination is to lay this over, get to some of the other measures, and then come back to it, and perhaps the sponsor of the amendment will make changes. Nope, she is very obstinate. But if needed, we will consider this. If needed, we will consider, or please consider that you have permission to make amendments to the amendment if necessary. Representative Geithner.
And thank you, Mr. Chair. And perhaps to shed some greater light, I think, on the discussion that we're having around the purpose of the Blue Book. In the binder that I was provided, I think we all got the same thing. There is a memo that's provided, and then there is extrapolations, if you will, of Colorado Constitution, Article 5. And Article 5, Section 2, Roman numeral, technically, I think, part of page 4 of our binder, or page 4 of that memo we were provided. It literally reads, it says, the fair and impartial analysis of each measure, which shall include a summary of the major arguments both for and against the measure, and which may include any other information that would assist understanding the purpose and effect of the measure. That's kind of how I see maybe the colloquial words that are being used. If you reference controlled substances, even with as late as August 2nd, 2022, mushrooms are used. And so I think that the point not only that the federal government is trying to get to is that mushrooms is a terminology understood by the public, recognizing, of course, what our Constitution, the Colorado Constitution says, any other information, let me get that quote directly, which may include any other information that exists in the understanding. And I think that's the purpose of the book. So I think the Constitution clearly defines why it is permissible to use the word mushroom, reflects back to federal government and the use of their word of mushroom, which is an understanding that the public has. It is consistent in what the public expects and how they understand this to be used.
Leader McKean.
Oh, no, I'm perfectly willing to wait.
Terrific. Okay, and Mr. Carpenter, not a big deal, but I do see at least one typo. So I'll let you know. And it's understandable because it's on the word psilocin. And I bet most people don't know how to spell that anyways. But we will lay this over to the bottom of the agenda and move on for now to Proposition 123. And we will now move back to Proposition 122. Do we have Some progress. Senator Donovan.
Thank you, Mr. President. I do have copies of Amendment 3. I don't think I was able to get to everyone, so is there anyone who needs a copy? Colleagues, thank you for your feedback and willingness to try to move this forward. Amendment 3 as is redrafted, focuses on the reordering and what I'm colloquially calling a cut and paste amendment.
Local.
Yes. Anyways, it doesn't change any existing language. It just reorders it. Happy to answer any further questions. Thank you, Mr. President. Thank you, committee. I also, sorry, Mr. President, I failed to move it. I do move Amendment 3 to Proposition 122. And thank you to staff for jumping on this and helping us figure it out.
Great. Any questions or discussion on Amendment 3? Senator Van Winkle.
Thank you, Mr. President. I know we've discussed this at length, and I just appreciate the hard work of both staff and the sponsor of this amendment to bring it to a place that seems to be consensus. So thank you.
Terrific. Thank you as well to Senator Donovan and staff for getting together and figuring this out. Seeing no further discussion, Ms. Wallace, please take the vote on Amendment 3.
Senators and Representatives Benavides.
Yes.
Basenecker.
Yes.
Coleman.
Aye.
Cook.
Aye.
Donovan. Escar.
Yes.
Gardner.
Aye.
Beitner.
No.
Hanson.
Aye.
Kennedy.
Yes.
McKean.
Aye.
Malika.
Yes.
Pelton.
Yes.
Smallwood. Valdez.
Yes.
Van Winkle.
Aye.
Moreno.
Aye.
Mr. President.
Aye.
It's 17-0.
That amendment does pass on a vote of 17-1. Any other amendments to Proposition 122? Seeing none, that concludes our discussion on Proposition 122.